We have reliance on Section 3 insofar as Article 2 gives states this broad power to determine how their electors are selected, and that broad power implies the narrower power to enforce federal constitutional qualifications.
Well, but the narrower power you're looking for is the power of disqualification, right? That is a very specific power in the 14th Amendment, and you're saying that was implicitly extended to the states under a clause that doesn't address that at all.
We would say that nothing in the 14th Amendment takes away from the states their broad and nearly plenary power to determine the manner of selecting their electors in the manner that they see fit. As this court said in Chiafalo, that power is nearly plenary unless something in the Constitution tells states they can't do it. And the structure of the 14th Amendment certainly was intended to expand federal power and certainly to restrict state power in some ways. But states are bound to enforce and apply, for example, Section 1 of the 14th Amendment. And so it's hard to see why states wouldn't be similarly bound or at least authorized.
That's not greater includes the lesser argument. The states have the power, the legislature has the power to choose electors, granted. But just because there's one authorized means in the Constitution to a particular end does not mean that there's any means to that end. And so I think you're taking that electors argument and bringing it into Section 3, where, as the Chief Justice says, there's just no, and Justice Thomas, there's no historical evidence to support the theory of Section 3, nor the overall, to explain the overall structure of the 14th Amendment.
We certainly have a long history in this country of states using their power to determine the manner of selecting presidential electors to enforce other qualifications in the Constitution. I don't take it there's a great debate about whether or not states are allowed to exclude underage or foreign-born candidates, or if President Bush or Obama wanted to run for a third term, that they could be excluded under that broad Article 2 power. I don't see why Section 3 should be treated any differently. Section 3 speaks in the same.
Well, when you look at Section 3, the term insurrection jumps out. And the questions are, what does that mean? How do you define it? Who decides? Who decides whether someone engaged in it? What processes, as Justice Barrett alluded to, what processes are appropriate for figuring out whether someone did engage in that? And that's all of what Chief Justice Chase focused on a year after the 14th Amendment to say, these are difficult questions, and you look right at Section 5 of the 14th Amendment, as the Chief Justice said, and that tells you Congress has the primary role here. I think what's different is the processes, the definition, who decides questions really jump out at you when you look at Section 3. Your response to that?
Well, certainly, Justice Kavanaugh, there has to be some process for determining those questions. And then the question becomes, does anything in the 14th Amendment say that only Congress can create that process? And Section 5 very clearly is not an exclusive provision. It says Congress shall have power.
But maybe put most boldly, I think that the question that you have to confront is why a single state should decide who gets to be president of the United States. In other words, this question of whether a former president is disqualified for insurrection to be president again is, just say it. It sounds awfully national to me. So whatever means there are to enforce it would suggest that they have to be federal, national means. Why does, if you weren't from Colorado and you were from Wisconsin or you were from Michigan, and it really, what the Michigan Secretary of State did is going to make the difference between, whether candidate A is elected or candidate B is elected. I mean, that seems quite extraordinary, doesn't it?
No, Your Honor, because